Hello, I'm Richard James of the James Law Firm in Conroe, Texas, here to talk about the event of your loved one has died. What do we do now? Well, first of all, for that loved one, before his death, he and his spouse should have an estate plan consisting of at least a last will and testament, a durable power of attorney, and medical power of attorney. Now, when that person dies, the durable power of attorney and the medical power of attorney have no more legal effect. The agents cannot act under those documents. If there is no will, or if there is a will, but you don't know what the other or what the assets of the estate are, then here are some pointers to take into account. First, especially if it's an unmarried person, secure access to the decedent's house. Make sure it's locked up. The air conditioner's set. Don't want to get it too hot. Don't want to get it too cold. Check the files inside the house and check the mailbox. Why do we do this? Well, you're looking for account statements, evidence of assets, life insurance policies, annuities, maybe even records regarding other real property. Now, if the decedent, has an estate plan, they often don't have a organized set of information, such as in a binder, and that's what we recommend here: is keep a binder with those important account documents, life insurance policies, annuities, other real estate owned, and other things you deem important. Have that so that your loved one uh, can find it and not have to play investigator to find assets. Also, check the deed records or hire a lawyer to do that for you. Uh, Secure a death certificate, which, without any unusual circumstances or death while alone, could take just a few days to a week. It could take longer. But with that death certificate, it is possible to get some of the assets, especially if the decedent only had one beneficiary or one heir. So if that decedent left a a asset that has a beneficiary designated to one person, with that death certificate, that beneficiary could obtain that asset. And of course, go see a lawyer. Try to schedule something within a few weeks after the death of the individual. Most people do not call a lawyer the day after. If the decedent has significant assets or a business to manage, then it is important to go see that lawyer sooner so that someone has the authority to act on behalf of the deceased estate. Now, if there is no will, then what do we do? Well, first you want to confirm there's no will. Look around the house. Look for evidence of a safe deposit box rental. Uh, Again, go see a lawyer. When you go see that lawyer, have a list of assets that you know about and debts, because when you go see that lawyer, the lawyer's job should be to determine whether or not a probate estate administration is needed in a probate court. In Montgomery County, we have statutory probate court number one. Harris County, we have statutory probate courts. They focus only on probate and guardianship. Other courts would be county courts. So you want to have that list of assets and liabilities so that we can determine whether we need a probate. Now we'll divide those assets into two categories: probate and non-probate. Probate assets pass through the will, or if there is no will, through the intestacy laws of the state of Texas. Someone will get the assets. You will not take them to the grave. And you will not take the debts to the grave. I bet you're really glad of that one. And then there are non probate assets. Those assets are typically those with a beneficiary designation, like life insurance, a retirement benefit plan, like an IRA or 401k or an annuity. But any bank account can be made non probate by designating a beneficiary called a payable on death account. So you want to have a general idea of what the assets are. You may not have any idea, but you probably know that most people have a bank account. And with a death certificate, you could go to that bank, take that death certificate, and see if you can get the money. If you cannot get the money, then it's either without a beneficiary designation or it has one and you're not the beneficiary. So that will help in deciding on whether you need to probate the estate. So once you have that lawyer's meeting and you hire that lawyer, then if there is no will, then he will file two applications, one to determine the heirs and one to administer the estate, sometimes combined together in one application. To determine the heirs, a separate app or an application is filed so that state law will determine who gets the assets of the deceased. It's also necessary to determine the heirs if you want an independent administration that's free from court supervision. The only way to get the independent administration without a will is to have an agreement among the heirs. Therefore, you have to determine the heirs. And then the other application is to administer the estate. And if you're not going to determine the heirs first to have an independent administration, you could have a hearing to appoint that administrator without determining the heirs. And that administrator would be a dependent administrator, one who is subject to the court's supervision. So a process without a will could last 6 months to a year or more. The law is written that an annual accounting is required. So if an annual accounting is required, then generally you think it's probably going to last a year. But if all the assets are administered, all the assets are collected, and claims are paid, and you're ready to distribute, then the court can be asked to approve an early distribution with the accounting, of course. So that is the general process of getting started to administer an estate. And it's a lot more work without a will than with a will. So I encourage you to have an estate plan for your family. Thank you.